Hello folks, welcome to Legacy IAS Academy. In this video, we'll be discussing a current affair topic presented to you by your faculty, Sushma KP. So what is the topic that we will be looking into today? High Court rules about arresting women at night. Now in this video, we will see why is it in use, what is the relevance of it to UPSC, that is your GS paper 2. We will also be discussing about your section 46(4) of your CrPC. We will be discussing your Madurai bench verdict. We will also be discussing about your Nagpur bench verdict. At the same point of time, we will see what is the impact of your Madras High Court ruling. We will see a possible mains question from this topic and also discuss a possible prelims question from this topic. Alright, let's get the video started. Now, look at this. What did the High Court rule about arresting women at night? We will see what is the legal provisions with respect to arresting a woman at night from your executive point of view as well as your judicial point of view. And then we will compare it to how it is important that these rules are followed. Alright, now look at this. In your Deepa versus yes Vijayalakshmi and others case, your Madurai bench of Madras High Court quashed a petition stating that yes, a particular rule of your criminal procedure code was not followed. What is that? Now I will explain it to you like a story. You listen to it like a story. Or leave all these things aside. Okay, just what I tell you, listen. Now this is a woman. Alright. As of now, let's understand you have something called as criminal procedure code. Okay. According to this section of 46(4), section 46(4) of CrPC, there is a rule that states that this woman, okay, let's assume she's committed some crime, or possibility is that she could have committed a crime. We're not certain, right? Now, whether if you have to detain her or whether you have to arrest her, this provision, this 46 of 4 tells that either before sunrise or after sunset, understanding, before sunrise or after sunset, you will not arrest or detain her, except in extraordinary circumstances. Understanding? Except in some of the extraordinary circumstances. Now what happened here was, in this particular case, a woman was arrested at 8 p.m. Fine? A woman was arrested at 8 p.m. What was the time limit that I told that you should not, according to your 46 of 4, they have told? It should not be after sunset and before sunrise. Now this itself will become a debated topic. When exactly is sunset, when exactly is sunrise? For different people it is different things, especially us. So for convenience sake, let's keep it 6 a.m. 6 p.m. Women should not be arrested before 6 a.m. Women should not be arrested after 6 p.m. Now in the case that I am telling, the woman was arrested at 8 p.m. Yes or no? Your Madurai bench itself, the 3 bench judges pay, only one judge was like, yes, the rules were not followed. That is, you have arrested women after 8 p.m. Whereas the other 2 judges were telling it's fine. Reason was why they had this differing opinion. Again, like I told you, in this amounted to breach of 46(4) is what one judge claimed. The remaining 2 judges were like, no, it is fine. Why did they tell that? Because again, like I told you, your 46 of 4 itself claims that according to your criminal procedure code, it tells that you cannot arrest or detain a woman after 6 p.m. or before 6 a.m. except in exceptional scenarios. One issue with this is they have not defined what exceptional scenario is. That is where the ambiguity is coming in. Now, if you see this issue, this particular provision, whatever is there, this brought in a little bit of confusion. Wherein your Madras High Court stepped in to tell that, see, when your legislative, that is your law making body, came up and told that in your section 46 of 4, that you should not arrest a woman after 6 p.m. and before 6 a.m. They have just told that only. They have not given any consequences to it. That is, let's say if someone still goes ahead and arrests someone, let's say a woman, at the ungodly hours that we have mentioned, then you will be having this penalty. So the penalty provision is not given in the law, meaning it indicates what? This guideline is mere directory in nature and it is not mandatory, which they used to tell that the arrest that was made for the women at 8 p.m. does not require to quash the case, telling that yes, it was a breach of 46 of 4. Understanding? Clear up until here? Yes. Now, your Justice G.R. Swaminathan and M. Jyoti Raman, who were the benches of your Madurai bench, again held that if there is no consequences of non-compliance in your 46 or 4, doesn't it indirectly indicate that it is merely directory in nature and not mandatory in nature? And again, when they've told that yes, the police officials have to justify or have to mention or define what these exceptional cases are, they're also trying to tell one important thing here is, if the police carry out their duty accordingly as to the law mentioned and not in any arbitrary manner. First and foremost, they've even highlighted this against arbitrary arrest. Once you don't do this, once you uphold the principles of your law, that is your police, the executive are upholding the law and following the law, means then the public trust will come on your public officials. If public trust comes on the public officials, then the public trust will increase in the public government services also. Yes or no? So this will be the very much essence of what your law is trying to convey, what your democracy is trying to convey. Yes, this is one of the inference that they have made from this. Another thing that they have come up and told is, first and foremost, let's go back to your article 46 of 4. According to it, it says that yes, not after 6 p.m., not before 6 a.m. arrest. Despite that, in case that you have to arrest that woman, understanding, it is a provision that states that then immediately you have to inform the magistrate. You have to get a permission from the magistrate. You have to inform your superior officials. Let's say a woman had committed a heinous crime and immediately you have to arrest, but this provision is blocking you, then that particular time that person can escape. So to prevent these kind of things in this emergency scenarios, okay, they can go to the magistrate, get the permission from the magistrate, or inform the superiors, or even that was not possible, then you have to inform the grounds of the arrest record. Yes, so all of this must be performed, and also there are certain provisions which states that you cannot touch the women unless and until it is a women constable. Understanding? So there are majority of the provisions which safeguard the rights, or which make sure that the vulnerability of certain section will not be affected. What do I mean by this concept? Vulnerability of certain sections will not be affected. That is what we mean by gender sensitive policing. This has now become a very increased concept now. For example, in the states of your Andhra Pradesh, is with respect to Nagpur, everywhere there is a demand for increasing gender sensitive policing, meaning you will not do any arbitrary arrests, but at the same point of time you will be properly conducting the investigation in the said so manner according to the rules specified according to the law. You will not have any arbitrary power or police excesses or red tapeism in any so manner in your executive. Understanding? So in simple words, you will not violate human rights, you will not violate article 21. Once the police conduct is proper, then the public trust on them will also increase, and thus increasing the institutional trust. Understanding? So your safeguards for arresting a woman at night is provided in your 43.5 and 46.4. Understanding? Now, What are some of the provisions? Restrictions on arrest timings, like I said, not after 6 p.m., not before 6 a.m. And a magistrate's permission is required if in case you have to arrest in this period of time. Understanding? And there is a protection against physical contact. You don't have to unnecessarily touch the women in unless and until, let's say, if it's a woman lady police officer or a lady constable who is present. This is what we said. One of the most ambiguous and confusing thing is there is a lack of definition for exceptional circumstances. Now, your judiciary also has highlighted that you have to bring in certain rules and guidelines to define what constitutes your exceptional circumstances so as to it cannot lead to your arbitrary arrests. Understanding? Now, mainly important, what we will see the background of your section 46 or 4, or where did this concept stem from the fact that you're not supposed to arrest a woman after 6 p.m. or arrest before your 6 a.m. We can trace its law to your 135th Law Commission report of 1989, which said that yes, a woman should not be arrested after 6 p.m. or before 6 a.m. At the same point of time, a lady constable should be present. Yes, and also to be detaining that person, also this provision should apply. Your 154th Law Commission report of 1996 also adhere to the same thing. Then finally, in your 2000, Section 46 of 4 was enacted in your Criminal Procedure Code with certain modifications. And now it is in your BNS. Let's say take a look of what your Nagpur bench of your Bombay High Court held the opinion of this particular matter, that is of your section 46 of 4. It said that even detaining a woman has to be followed in the same way, that is not after 6 p.m., not before 6 a.m. And a lady constable has to be present, and at any cost a woman should not be arrested after sunset or before sunrise. Now, based on this version of your Nagpur bench, your Supreme Court highlighted this provision will make it practically difficult. The practicality of this will become very difficult. Okay, so where this is an indication that your judiciary was also not very much okay with this, because again, let's say a woman has committed heinous crime and tries to escape, and you can't nab or catch the criminal because of this particular provision. Now, with your Madras High Court coming and justifying that no, it is not mandatory, this provision is not mandatory but just directory in nature, what is the impact that it can have? First and foremost, you just because yes now it is not mandatory doesn't mean you will go on for arbitrary arrest. They have mentioned that there should be an obligation to justify the non-compliance on what? That you have not followed the time limit. Why had you had to arrest at that period of time? So you have to give a justification, and there should be a clear guidelines as to mention as to what will contribute to your exceptional cases. Understanding? What is the difference between CrPC and your BNSS? See, it is your BNSS has replaced parts of your CrPC. This is more stricter, stringent laws. Okay, it has also brought much of digitization and to suit to your modern law system or modern legal system. So it is more adaptive than your CrPC. Let's look at a possible mains question. Discuss the implications of nighttime arrest for women in India, citing relevant provisions from the Code of Criminal Procedure. That is what we discussed. The summation of it is what you're supposed to mention here. Let's look at some prelims question. Which of the following provision of the Code of Criminal Procedure governs the procedure for arresting women at night? Section 46, Section 47, Section 51, Section 160. The correct answer is Section 46. Alright, let's look at the next question. According to the CrPC, what is the time limit for arresting a woman at night? 6 p.m. to 6 a.m., 8 p.m. to 8 a.m., 6 a.m. to 6 p.m., except in exceptional circumstances, 12 a.m. to 12 p.m. The correct answer is 6 a.m. to 6 p.m., except in exceptional circumstances. Now that's it. We've come to the end of the content. If you like our content, subscribe to our channel, hit the like button and share it along with your friends. Thank you.